Everyone, thanks for joining us. We know everyone's busy, so we appreciate you taking some time out this morning. This is Will Hussey with Maher Corporate Risk Associates. I handle the health and benefits insurance for our commercial clients. And with me this morning, I have Rick Maher. Rick is our in-house HR expert here. Rick is with Davis Maher and Associates, and Rick is going to be presenting this morning on the Wage Theft Prevention Act. This is a new law in New York State that the state really has not done a good job of notifying employers on. In Rick's terms, this is a revenue generator for the state. It's something that all employers need to comply with, regardless of size. There are a few exclusions in terms of who needs to comply, but for the most part, everyone does need to be in compliance with this by February 1st of this year. It's a fairly simple law to comply with, but it can be a little confusing in terms of getting all the forms straightened out and notifying your employees. So we have a PowerPoint presentation that we're going to go through this morning. The presentation should only take about 15 to 20 minutes, and then there will be time for questions at the end. Hopefully you'll see on your screen there's a box where you can ask questions. So just jot your questions down as we're going through, and then we'll give some time at the end to allow for everyone to ask their questions. So without further ado, I'll let Rick take over, and we'll start the presentation.
Good morning, everybody. So as Will mentioned, this is a new law, a new gift to us by the state of New York. And what we want to make sure today is that everyone knows what they need to do to protect their business for February 1st and going forward. So the new law is the New York State Wage Theft Prevention Act, or WTPA, and the law was signed into effect in December of 2010. Well, it was signed into law. It went into effect in April of 2011, and the deadline for compliance is February 1st of this year, and so we're quickly coming up on that. And folks are, not a lot of folks are completely aware of this, so we wanted to make sure that if you are, you know what you need to do to be in compliance, and if you're not aware, you're now aware and know that there's a resource here for you. So, New York State Wage Theft Prevention Act. I'm sorry, let me see here. The purpose of the agenda of the training. The purpose of this is not to debate whether the good, honest employers of New York are being overregulated by the state or any of that stuff. That time has come and gone. The purpose of this training is to make sure that you know what you need to do in the next couple of weeks to be in compliance with this law, and also what you need to do going forward on a yearly basis to make sure you're compliant with the law. We're going to talk quickly about some of the Act highlights. Again, it's not going to be a legal dissertation, but it's just talking about some of the high-level things you should know. We're going to talk about the risks of not complying. We're going to share with you the approved documentation from the New York State Department of Labor that you can use. Then we're going to talk about what you should be doing at the company level, and let you know that you have a resource in Maher Corporate Risk and the HR services that we provide. And then finally, just some case studies. And then we'll take a few minutes for questions. So as Will mentioned, if you have a question, type it in the box. We'll go through the training and then make sure that we go back and clarify any questions. So again, the purpose of the training, as I mentioned, is not to debate the law. That time has passed, but rather to figure out the things that you need to do to be in compliance. So the Act highlights. Why? When this law, just to give you kind of a flavor of what we anticipate the state will be doing with this law, when this law was signed by then Governor Patterson in December of 2010, his last week in office, his quote was that the employers of New York State have been stealing from the employees for far too long. So that kind of gives you a flavor as to the why, and why the folks in Albany decided to put this law in place, which is the most aggressive in the country. So that's the why. So what does it do? What does this act clarify, and what does it expand in labor law? So as you see those bullet points there, it really broadens the ability for the Department of Labor to enforce labor law. It expands the employee's ability to bring complaints against you or the employer. It expands the employee's ability to bring civil actions, private actions. And a big thing is it expands the definition of retaliation, which retaliation has always been illegal, but it expands it in such a way that employers could get in trouble for perceived threats, and we'll go through those. And then also, we'll go through this again later on in the presentation, it was always, it could always be cited for retaliation, but now it is illegal, and we'll talk a little bit about that further on. Okay, so who must comply with this? All private sector employees are covered by this law. So if you're in the private sector and you have employees in the state of New York, they are covered. If you're an employer, and you have an office on Long Island or what have you in New York, but you have 10 employees in New Jersey, this law does not apply to those employees in New Jersey. It's only for New York-based employers or employees. So what types of companies or organizations? All non-public entities, including charter and private schools and nonprofits. So state, federal, and local government organizations are not covered by this law and do not have to worry about its ramifications. So what are the basics for compliance? Each year, and each year between January 1st and February 1st, which that's the period we're in right now, every single employee must be provided a compliant pay notice. And I will share with you some of those documents later on, approved from the state. And it must be in that employee's primary language. So if they speak Chinese or Creole or French or Spanish or those kinds of things, it must be provided in that employee's primary language and have the employee sign off on it. And we'll share with you some of those documents again later on. Each pay period, and every employee must get a wage statement. So for most of you who are using some sort of payroll company, typically they're providing wage statements in their paycheck. Well, they've expanded the amount of information that must be on that pay stub. So you want to make sure with your payroll provider, or if you're writing checks out of QuickBooks or whatever, that you contact someone to make sure that your wage statements are compliant. Records now must be kept for 6 years. So we're encouraging folks that are in charge of making sure that employees have annual pay notices, and people who are in charge of making sure that the wage statements are properly done, that they find a secure place to keep 6 years of records, and make sure that there is a succession plan should you leave that position for some reason, that the next person who fills your shoes or someone at the organization can come in and say, okay, here are the 6 years of records for pay notices and wage statements. Then finally, what we'll talk about is the basics for compliance. You can use your own forms. You do not have to use what the state provides, so you can make up your own. So we'll go through some of the pitfalls of using the state's forms a little later on. Okay. The risks of not complying. So as I mentioned, there's two forms that you must provide employees each year. One is the pay notice, and that's a document that's provided at the time of hire. And I'll show you a copy of that right after the slide. That tells the employee how they're being paid, what they're being paid, any sort of deductions that are being taken out of the paycheck, and that must be provided to the employee at the time of hire and yearly between January 1st and February 1st. So this is where we are in the stage of this cycle. Is we're in the January 1st to February 1st pay notice pay period, and after this there will be no grace period. Each worker who's not provided a pay notice you can be charged a penalty of $50 per employee per week. With each worker, able to sue for damages of up to $2,500. But the bigger problem is a potential for a wage and hour audit. So, what we're sensing from employers is that they have to make sure that all of they're paying people properly on the backside, because if there is some sort of judgment or suit against the employer, we expect that the Department of Labor will come in and do a wage and hour audit, which could become, as you'll see some case studies, very, very, very costly. So anyway, back to pay notices. Typically, there are two types of forms for a pay notice. There is the LS-54. The LS-54 is for people who are generally paid hourly, so they're eligible for overtime after 40 hours at time and a half. And then there is the LS-59, and that is for folks that are generally salaried. And so we'll show you some of those forms. So this here is the LS-54. So this is the state's version of this form, and certainly you can use your own version as long as it has the appropriate information. And you can see on the bottom left-hand corner, there's the designation that this is the LS-54, and it's a March 11 form, so you can see that. So this is for someone who is hourly. This should be filled out with the employer information. It should be provided to the employee and signed off by them, and it should be kept in a secure and an accessible file. You'll see where it says check 1 on the right-handmost column, that it was provided in English because it is my primary language, or it's provided in whatever my primary language may be. And I'll show you where to get those forms on the Department of Labor's website a little later on in the presentation. But this must be signed, given a copy, and kept for 6 years. Okay, this is the LS-59. As I mentioned, the LS-59 is generally for folks that are hourly. I'm sorry, this is for folks that are salaried. LS-59 is for folks that are salaried. So again, it looks very similar. One of the things that we would caution is that if you look in item number 7, overtime pay rates, this is for salaried people. So generally a salaried person or exempt person is not eligible for 40 hours overtime after 40 hours. But you'll see that bottom sentence where it says, list why the employee is exempt. And it says optional. The feeling on the street from various labor law experts who have looked at this is this might not be something you want to fill out, because if you fill it out incorrectly, it's going to be on file for 6 years and could come back to bite you. So if you need guidance as to why you would or would not fill out that box, please see either someone from Marin, call Marin for HR support, call your employment attorney, but make sure that you're doing it properly. And this is why we would suggest that it may make sense to look at having your own forms so that it's tailored to your business. It has the information the state needs, yet it doesn't have extra information that could potentially get you and your business into trouble. That's the LS-59. Okay, risks of not complying. Now, wage statements. This is different than pay notices. Wage statements are, think of, your employee's pay stub. So, again, here's another opportunity that if it's not done properly and it's not accessible by the employees, it's $100 per employee per week is what they can get as a penalty. And each employee can sue for up to $2,500 in damages. Again, just like the pay notice, the real scary thing about this law is not the $100 fines or the $2,500, although those are very scary. The real scary part of this is the potential for wage and hour audits. So we would encourage folks to look at how they're classifying folks, how they're paying them, are they paying proper overtime, because that's going to be where fines and fees can get astronomical. All right, so you see later on that there's a place to get the wage statement or a copy of what a wage statement should look like, because there's lots of different information. So you can go on and look when we give you the website at the end of the presentation. Okay. Risks of not complying. I mentioned before retaliation in the beginning of the presentation, and retaliation has always been illegal. It's always been, for discriminating against an employee that's filed a complaint. But now they've added to the definition of retaliation, and now it's any perceived threat is considered a form of retaliation. So let's talk about some examples. If you move an employee's desk, that could be seen as retaliation. If you change their job hours, if you even speak to them, and the employee perceives that as a threat of retaliation, then the employer could be in some serious trouble, and could be in trouble even if the employer did not do anything wrong, but the employee acted in good faith in reporting the employer. The employer is still on the hook. So retaliation now is expanded that any perceived threat, and that's perceived by the employee, is going to mean additional fines and damages that could be levied upon the employer. So WTPA, Wage Theft Prevention Act. Okay? It provides for higher penalties when an employer is found to be in violation of paying improper wages. So you can see there, in the old way of the act of the law, liquidated damages were 25%. It can now go up to 100% of unpaid wages. So there's some, you can see there's some significant risk, financial risk. And there are other penalties that are described in a fact sheet that we're going to provide to you at the end of this presentation. So at every level, the risk of not complying has lots of different ways for the employee to sue the company or get damages from the company. But even more importantly, it opens the door for the Department of Labor to come in and do various types of audits that could be really business crippling, if you will. So approved documentation, you saw a couple of those forms. A fact sheet, if you ask for a copy of this presentation, a fact sheet and some frequently asked questions will be provided to you. Here's a website, so I'm going to do a little filler of time on this part of the conversation, so if anyone wants to copy that down for today. Sometimes when you go on the Department of Labor website, it can get a little confusing of forms and where they are. This is where all of the forms will be housed for this new act that you must comply with in the next 2 weeks. So again, when we said if you ask for a copy of the presentation, all the forms will be attached and sent with it. And specifically, you'll have this Department of Labor website that you can go on and get those forms. So I'll wait another 10 seconds if anyone's writing that down. Okay, let's move on. So what people have said to us and said to their Marin account executive or salesperson or really anybody at Marin has been, how come I feel like I'm not completely prepared for this law or this act? And as I mentioned earlier, it seems as though the state has not done a great job in communicating this, because the sense on the street is that on February 2nd there will be a lot of various knocks on the doors, and people will not be in compliance with this because they don't have a firm like Marin advising them and making them aware of this. And it's going to create some really big problems. So if you feel like you're not completely prepared, it's not uncommon. That's the purpose of this call, and that's what we want you to know, that you have a resource here at Marin Corporate Risk to reach out to and get some assistance. Another question that continually comes up is, well, I don't have to give this to my existing employees, do I? Yes. Every single employee must get a pay notice annually, which is between January 1st and February 1st, and a proper wage statement each payroll period. do I need to give to new hires or seasonal or part-time? Anytime someone comes to work for you, even if they're coming back to work, even if it is a seasonal company, when they come back to employed status with you, you must provide them both notices so that you're in compliance. Do I need to give a notice for each pay raise? The answer is yes. Anytime there's a change in someone's pay, it should be reflected on a pay notice, which is the one they sign up front that's in their primary language, and it is noted on their first pay period, pay stub. Okay. What if an employee refuses to sign? There have been some instances of this already, and what is advised by the state is that you ask the employee to sign, you note it that they refuse to sign, and make some sort of documentation that you can attach or keep in that person's file, so that if it is asked, if you do get asked for that documentation, you can quickly recall the facts. But more importantly, because these forms need to be on file for 6 years, the person who has to deal with this in 3 or 4 or 5 years may not be you, and that person needs to know the facts as to why this person did not sign. Okay, so it's an administrative thing that you need to make sure of. Okay, so here are 3 case studies of what things that have actually happened prior to this act going into effect, and kind of the things that we expect to see going forward. So the first case study, very quickly, was the Department of Labor chose a certain field. So they chose 46 Long Island restaurants. This was over the summer and probably ended in the October timeframe. So it is not old at all. They chose 46 restaurants. 35 of the 46 were out of compliance as to how to pay properly. So that's a pretty significant number, 75%. The findings were that $2.3 million in back wages for 578 employers was to be paid by these restaurants. So pretty hefty fine, pretty hefty amount of money that needs to be come up with. And it does not. This number, the $2.3 million, does not include fines or back taxes or legal fees or any of those things. So that number was significantly higher. So to go back to the original slide when we said, why is the state doing this? They know that a lot of businesses are out of compliance, and it's almost like shooting fish in a barrel. So that's case study number 1. That was a targeted industry that was done. Case study number 2 is this was an employer had a couple of complaints against them from a couple of different employees, and it was what I would call a truck and technician company. So what that means is a company that has vans that go out and service employers. Think of HVAC types of companies, refrigeration repair, landscapers, those kinds of companies that have trucks that roll out of their shop every day and go and work on various clients' work. So an agent walked in unannounced due to an anonymous complaint. So now we don't know if the agent was just kind of cold calling and looking for business and figuring that this type of a company fits the profile, or there was truly complaints. We would never know that. At the company, there were 35 employees. The agent that walked in unannounced asked to see all the pay records for the past 3 years. And the employer then had to scramble to find them. And as you can imagine, a company of this size doesn't have a vault and things like that. It was very difficult for them to find all the records. The employees were interviewed off-site, and the employer was found to be out of compliance and owes more than $200,000 in back wages, taxes, fines, and fees. So again, this is the kind of thing that we expect to have happen on a greater scale as this law takes effect, because these types of actions or investigations are the direct result of people who maybe miss complying with the Wage Theft Prevention Act, and therein lies the ability for the government to come in and do a wage and hour audit. Then, case study number 3. This is again is a a recent development in the past 7 or 8 months, a recent case. Most people say, "Hey, look, we're a professional services company. We don't have to, we don't have to worry about this." Well, that's not true. So here's the example. This firm has 75 employees. They decided to pay their clerical staff a quote-unquote salary to avoid paying overtime. So a person is not exempt or non-exempt because they are what their title is, but it's rather their job function. And most employers miss that, and it creates a big problem for them. The second thing they did was they gave people the title of manager, quote-unquote again, to accommodate an employee's request for title. But as the employer, that meant they didn't have to pay overtime. Well, the person's function wasn't really a manager, and there's definitions of what needs to be a manager. So again, the person didn't meet the smell test, if you will, of being a non-exempt an exempt employee. They were really a hourly type of employee. In both cases, these people were misclassified and were eligible for overtime. The firm was fined and had to pay back wages in excess of $100,000. So as you can see, these are 3 things that happened in the relatively near past, and we expect this type of stuff to be commonplace as a result of the Wage Theft Prevention Act, and why we wanted you all to see what was going on so that you know that you have a resource. So here is the phone number. Here is the email if you need to contact us, or contact your Marin account executive, sales rep, customer service person. But call somebody. Don't try to bury your head in the sand and hope that this thing goes away, because it won't. Okay. So that's really it. If there are any questions, I'll give a few moments for folks to type them in, and we'll make sure that those get answered, and we'll go from there.
But while we're waiting for people to just type their questions in, I did want to take a minute to thank Rick for his expertise and allowing us to take his time to present on this. We pretty much know that most employers are not going to be in compliance with this by February 1st, so we think this is a valuable resource for the Marin clients to be able to get access to this information and ask questions as to clarifying what forms they need and how they need to be filled out and who needs to, get these forms, et cetera, et cetera. So, we think there's going to be a lot of companies out there that are, out of compliance and opening themselves up to some liability. For anyone that's on the call today, this is our shameless plug. If you do have business associates or people that you do business with regularly and they don't have access to the type of expertise that you guys do as Marin clients, please send them our way. We love referrals. It's probably the biggest way that we get new clients. So, I'll just leave that out there. And I think we have some questions coming in, so I'll let Rick handle those.
So everyone, we will, if you want the copy of the presentation, just please contact Will Hussey, and then he'll get it to you with all the attachments and all that kind of stuff. Another question just came in, which is, if I am a local town government, do I have to comply with this rule? And the answer is no. This is for private employers, and it is for private employers, charter schools, and private schools, and nonprofits. So if you're a nonprofit, you must comply as well. Okay, it looks like that's it. So if you have any questions, please call into MCRA, and we'll go from there. Thank you, everybody.
Thanks, everyone. Have a great day.